A 1989 graduate of Georgetown University Law Center, Francine Ward is a copyright and trademark attorney with a focus on helping individuals, entrepreneurs, and small business owners protect their valuable creative content, brand, designs, logos, trade secrets, and company structure. Over the last 2 years, she has expanded her expertise to incorporate social media law, which includes counseling clients on avoiding the legal landmines resulting from playing in the social media sandbox. Francine Ward is an active member of the American Bar Association, the National Bar Association, the California State Bar Association, the LA Bar Association, and the San Francisco Bar Association. She is also a member of the Second Life Bar Association. Francine believes that staying updated on the law and current trends has played a big part in the success of her practice. A frequent speaker on legal issues and a popular legal commentator, Francine Ward can be found on Twitter, Facebook, and in the virtual world's Second Life. Her specialties are trademark, copyright, publishing, social media, business contracts, and business formation.
So today what we're going to talk about are social media ethical issues. You know, for those of us as lawyers, not only do we have to be concerned about the legal issues, but we also have to be concerned about the ethical issues. Today we're going to talk about 8 of them. I've done some research, I've looked at the model rules, I've looked at some local state rules, and we're going to focus on 8 different ethical considerations in particular. What I'll do is share with you the model rule. I'll share with you a little of how it actually can be, you know, how it shows up in the social media setting, and I'll let you know what some states have been doing about these. So let's get started. First, you'll find actually in the materials I have a link to, I have a lot of materials included, but I also have a link to the model rules on the ABA, the American Bar Association website. So the first ethical consideration is fee sharing with non-lawyers. So the model rules actually state in Rule 5.4, professional independence of a lawyer, and in essence, they say that a lawyer shall not form a partnership with a non-lawyer. That's essentially what the rule says. And the rule is here. I've included all of the rules in the materials. A lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment. North Carolina Bar in February of this year actually spoke on this issue with regard to selling discount services on a website called Groupon. How many of you are familiar with Groupon? Some of you. It's a website that provides coupons for products and services, for a variety of products and services. And in fact, lawyers have been participating in this. And the North Carolina Bar recently, in an opinion dated February 2nd, 2011, they basically said that, the North Carolina Bar staff prepared a draft opinion regarding a lawyer's participation in the marketing service such as Groupon. And they concluded that a lawyer's participation would indeed violate the North Carolina Rule of Professional Conduct 5.4a, which forbids lawyers to share legal fees with non-lawyers. And how that really shows up is if you're on a service like that, if you're participating in a service like that, you in fact have to pay them a fee. You pay them a fee in order for them to advertise your services. That's where the issue arises, that you're sharing fees with non-lawyers. So at this moment, North Carolina is the only state that has actually provided a legal opinion, an ethical opinion, but you can rest assured that other states will surely follow. So the issue here is just be really careful when you're participating in a lot of these online marketing services, especially if they're asking you for some sort of kickback, some fee or something in exchange for them providing a service for you. The next ethical consideration is the unauthorized practice of law. And essentially, we all know what that means. That basically means that if you're not licensed to practice law in a particular jurisdiction, then you can't practice law in that jurisdiction. The Rule 5.5 speaks to unauthorized practice of law, and it says, in part, a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another person in doing so. The ABA just recently came out with, the ABA Commission on Ethics came out with its 2020 report, which is actually very recent, and I've included it in the materials. In relevant part, here's some of what they have to say. There are a number of jurisdictions that treat this issue of multi-jurisdictional practice differently. So let me share a little bit with you. 8 jurisdictions, Connecticut, Idaho, Kentucky, Maine, New Jersey, North Carolina, South Carolina, and Tennessee require that temporary legal services which are provided in the host jurisdiction be reasonably related to the representation of an existing client in the jurisdiction where the lawyer is licensed. So that's 8 jurisdictions. That's what they have to say. But then, let's take a look at a few more. 6 jurisdictions, which include Delaware, the District of Columbia, Florida, Georgia, Pennsylvania, and Virginia, excuse me. They permit temporary practice by foreign, non-US lawyers. Plus, North Carolina's rules appear to permit such temporary practice by omitting references to the words US jurisdiction. Again, I've included a link to the entire report. You can take a look at it, but these are just some pieces of the report that I think are important for us as lawyers in different states. The other is 4 jurisdictions actually. Connecticut, Nevada, New Jersey, and South Carolina require out-of-state lawyers to register in the host jurisdiction and pay a fee. So that's interesting. So if you're a lawyer, let's say you're a California lawyer and you want to go practice, or you have a client in Connecticut or Nevada or New Jersey and South Carolina, you may be able to do some work there on a limited basis, but you also have to pay a fee. 2 jurisdictions, New Mexico and North Dakota, require the out-of-state lawyer to associate with an in-state lawyer in transactions involving issues specific to the host jurisdiction's law. And then 2 jurisdictions, Minnesota and Wisconsin, provide that the lawyer would not be disciplined in the state in which the lawyer is licensed for engaging in conduct in the host jurisdiction, if it's permitted in the home jurisdiction. So that's interesting too. So Minnesota and Wisconsin, if you're a lawyer, let's say for example in California, and you would not be disciplined for performing certain services in California, Minnesota and Wisconsin might allow you to, within reason, practice law on a limited basis in that state. So again, this is a really interesting report to take a look at. Finally, 1 jurisdiction, South Dakota, requires out-of-state lawyers to obtain a sales tax license and pay applicable fees. So that's very, very interesting. South Dakota, who would have thought? So the full report can be found on the American Bar Association's website. Here's a link to it. We can just take a quick look here. There it is. So the report's actually, it's very lengthy actually, but it could be some useful reading. About 10 pages. Okay. One state, Colorado, has a very interesting approach. Colorado, in fact, with regard to jurisdictional, multi-state jurisdictional issues, Colorado has adopted a rule governing admissions to the bar, it's Rule 220, which permits a lawyer who is licensed in another state to practice freely in Colorado on a temporary basis, subject only to pro hoc vici requirements, so long as the lawyer does not take up residence in